Good morning, distinguished members of the House Committee on Small Business. Thank you so much, Chairwoman Velasquez, for inviting me to speak here today, and thank you as well, Ranking Member Shabbat. I have been the legal director at Legal Momentum for 5 years, and I'm very happy to have the opportunity to contribute today to your consideration of the Small Business Administration's proposed rule for implementing the Women's Procurement Program. I can summarize my testimony very briefly, but of course I will go on for 5 minutes. The SBA has correctly named intermediate scrutiny or heightened scrutiny as the constitutional standard that the Women's Procurement Program must meet. And the program, as Congress created it, meets that standard. It is substantially related to the important governmental objective of redressing and ending discrimination against women-owned businesses. The SBA's proposed rule, however, would require federal agencies to make a public finding that the particular agency had discriminated against small women-owned businesses in particular areas of, in particular industries, in their own procurement practices before they could let a single contract under this program. This is an emperor has no clothes moment. The SBA's requirement is frankly preposterous. It has no basis in law and would doom this program. I used to represent the federal government against discrimination claims as an assistant United States attorney in the Southern District of New York. And I can assure you, no federal agency will ever voluntarily make a finding that it has discriminated in its contracting practices. It's absurd. The proposed rule would guarantee that no woman-owned business would ever benefit from this program. It's an insult to the Congress that created the program, and it's an insult to women like those on the panel today who own small businesses and are the driving force behind economic growth that this country needs. Congress created the Women's Procurement Program against a background of persistent discriminatory barriers faced by women-owned small businesses in government contracting, and amid evidence of the federal government's continuing failure to award even a mere 5% of its contracting procurement dollars to these businesses, despite the goal that was set to do so in 1994. And my written testimony details some of the evidence that Congress has had available to it over the years of discrimination against women business owners. There can be no doubt that the program meets the Constitution's requirement that it serve a substantial government objective. The Constitution also requires that gender-conscious means like the Women's Procurement Program be substantially related to the achievement of their objectives. Congress met this requirement by limiting the availability of the program to small women-owned businesses in exactly those industries where they are underrepresented in federal procurement contracting. This type of limitation is exactly what courts look for when they assess the scope of affirmative action programs. The SBA's proposed rule would go far beyond constitutional requirements into unrecognizable territory. It would impose an unprecedented and entirely unwarranted condition on a well-crafted program by actually barring any federal agency from letting a single contract under it without first making, quote, and I quote this from the introduction to the federal rule as submitted by the SBA, a finding of discrimination by that agency in that particular industry. As I said, this is truly remarkable. What agency would ever announce to the world that it had documented its own history of sex discrimination in awarding contracts? I can only imagine the rush to the courthouse the next day by disappointed contract bidders, a rush that would be fully justified. Of course, there's no precedent for such an absurd requirement, nor any constitutional justification. To the contrary, the Supreme Court flatly rejected the position that the SBA is taking here, that the government may take affirmative measures only to address its own discrimination. The court dealt with that forthrightly in the landmark Croson decision. Now, the Croson decision for the first time required strict scrutiny of a race-based federal affirmative action or state affirmative action program. It was a ruling that drastically reduced the scope of affirmative action programs. And yet in that ruling, the Supreme Court said the government has, quote, a compelling interest in assuring that public dollars drawn from the tax contributions of all citizens do not serve to finance the evil of private prejudice. And that was nearly 20 years ago. Courts evaluating sex-conscious measures to enlarge opportunity have held explicitly and over again, as was noted this morning, that it is perfectly acceptable for such remedies to address societal rather than governmental discrimination against women. As lawyers who work to advance the rights of women and girls, we at Legal Momentum are frankly astonished by the SBA's actions here. After so many years of stalling, the agency has finally promulgated a rule to implement the Women's Procurement Program, only to include what can only be called a poison pill. Far from finally fulfilling its duty to implement this congressionally authorized program, the SBA's proposed rule would render it a nullity. And if I could just very briefly, I do want to flag for the committee the issue which is not addressed in my written testimony, but I would urge you to get further expert advice on the methodology of the RAND study. In particular, the way that the dollar value disparity measure is calculated. It says that if government spending for women-owned businesses, small women-owned businesses, in proportion of all spending in the industry, is proportionate to not the number of women-owned businesses in that area, but the dollar value of those businesses in comparison to the dollar value of all businesses in the industry, then you have parity. That means that small businesses are always going to be a very small fragment of the total dollar value of businesses in their fields, or most often they will be. So very small amounts of government spending will always produce parity when you're using that kind of measure. It's not how many dollars did we spend on women-owned businesses compared to what percentage of the companies in the field are women-owned businesses. So I would, as I said, I'm not an expert in the area, but I would really urge you to get another look at that. It is not the way that most disparity studies are done, and it definitely bears further scrutiny from you. Thank you so much.
Thank you.